I'm sure by now you guys have all heard about the Tiger Woods DUI situation. Tiger Woods was in Florida driving, and there was a crash. And when the officers came to the scene, upon their investigation, they had him do all kind of field sobriety tests, of which he voluntarily did, which in certain states you don't have to do them. You can say, no, I don't want to do it. However, once you have been arrested, like in California, once you have been actually arrested for a DUI, then you are required to submit to a chemical test. Whereas in Florida, I think Tiger Woods, once he was arrested and taken to the stadium, to the precinct, I think he refused to do the urine test. I'm not really clear on those facts, but I think he refused it. Whereas here in California and in certain other states, once you are arrested, you must actually take the chemical test once it's post-arrest. And actually you actually imply consent to that once you get your license. But things are different in every state, so talk to an attorney in your local jurisdiction, and they'll inform you of how it goes. But here, the thing that really bothers me about this case is the one thing that grinds most attorneys' gears is that the talking. Most attorneys it really makes us get out of our skin when you hear about your clients talking to law enforcement, specifically in a capacity of where the law enforcement is doing some investigating on some sort of criminal activity or alleged criminal activity that's taken place, and people just run their mouth. It does not help. And there's no further proof of that when you look at the Miranda warnings. When the Miranda warnings said, part of it is like everything you say can and will be used against you in the court of law. If that is the case, just understand your statements cannot be used for you. It will be used against you. So why would you already give them any ammunition to work against you? If you look here at the Tiger Woods probable cause arrest affidavit, it shows here that Tiger Woods, or his name Eldrick T. Woods, and in this arrest affidavit the officer put out, and it was released to the public. And they talks about everything I just mentioned about his field sobriety test, of how he did them. And at the end of the arrest affidavit, you see the officer made their objective conclusion, stating that based on my training and knowledge of experience, I believe that Woods' normal faculties were impaired and he was unable to safely operate a motor vehicle. Now that's the officer's actual contention. It's not actual definitive. It's just their contention, and that's what they would submit to the district attorney. And if this goes to a DUI, a full-blown DUI trial, then of course the officer would have to come in and testify to this report. But one of the things that I find really damning is what I just mentioned earlier about talking to the police. Here, in this case, the officer asked Tiger at the scene. He asked him a question. He asked Woods if he consumed any prescription medication, to which Woods stated, "I took a few." Now that is where that stands out in my mind. It's like, wow, that's problematic and that's lethal for his case. Is it enough for the DA to win a DUI case against? Not necessarily, but it just gives them ammunition. And one thing about it is that when you have statements like this, they can be used against you. And I know there's a lot of people who watch this channel say, well, how can that be? Isn't it hearsay? And that's actually perceptive. Hearsay is inadmissible. You are correct. What is actual hearsay? If you look at the Florida statute, because this took place in Florida, even though most hearsay evidentiary laws are the same around the country in regards to hearsay. But if you look at Florida statute, hearsay says hearsay is a statement other than one made by the declarant while testifying at a trial or a hearing, offered in evidence to prove the truth of the matter asserted. That's pretty much hearsay everywhere. Basically, if you make any statement that's not made in trial, not made in a hearing, basically when you're under oath, then and you made it outside of court, then that's going to be hearsay. And it's out of court, which means it is inadmissible. Hearsay is pretty much inadmissible in almost all states. I can't think of a state on top of my head where they say, oh yeah, hearsay is admissible. It's not. Hearsay is inadmissible. However, good lawyers always find a hearsay exception to make it admissible. And one of the biggest things they do is that they go to one of the exceptions, and the biggest exception they always use is the admissions. If you look here at the Florida Code for evidence, you look at the admissions, these are the exceptions, and there are several exceptions to hearsay. But look at the exceptions here. The first one that they're going to use, more than likely, is going to be admissions. And what is admissions? Admissions is a statement that is offered against a party and is the party's own statement in either an individual or representative capacity. Who made this statement in this case about taking the pills? Tiger Woods himself did. And who's bringing the claim? The state of Florida is bringing the claim, and they're going to use his own statement against him. It's an opposing party admission. That's why you do not want to use any statements. I always tell my clients, I say, listen, I know you want to plead your case on the street, which is the wrong venue to do so, but you always want to tell you always want to tell law enforcement that what you know and how right you are and how wrong they are, which does not help. I always tell them, if you must say anything, just say, I assert my Fifth Amendment Miranda right to an attorney. And let your attorney, because your attorney statements will not come in. It's only your statements that they focus on to get it in. Otherwise, it'll be hearsay. But if there's a hearsay exception, that's what could be damning to you. And that's what bothers me about this statement. Now, does Tiger Woods have a winnable case? Absolutely, even with this hearsay admission, but it will give the prosecutors more ammunition. So, and they're also going to bring the fact that he had DUIs in the past, which again would be objectionable because that's improper character evidence. But are there exceptions to character evidence? Absolutely. So you don't want to play these games. You definitely just want to keep your mouth shut. And I always tell people, let your lawyer do your talking for you. Let your lawyer represent. That's what we do. Contact your attorney and state that you assert your right to your attorney. But anyway, if you're the judge in this case, what do you think? I mean, do you think Tiger Woods was impaired? Do you agree with the officer here? You've all seen the video. I saw it. I thought he looked like he was a bit impaired, but he actually blew 000 if I'm not mistaken. But I don't know. This stuff can go. It's a judgment call. So you tell me what you think. Put it in the comments below.